Good afternoon. Good afternoon. Good afternoon. I'm also streaming on YouTube at the same time and streaming on Facebook because I want to share my experience together at the same time. Um, I'm sharing it together at the same time. So I'm just thinking and make sure that everyone can hear me at the same time. You know, if you can hear me, please let me know so that I don't run behind the clock. You know. Don't call me now, please, anybody, because I'm on a live YouTube and a live Facebook at the same time. The issue here is that we just had a Zoom court hearing, and I want to share my experience for the first time after the pandemic, on court hearing matter with the public at large. And I want people to understand. I want to welcome you on Facebook, and at the same time, I welcome you on YouTube. All those who are there to join me perfectly. Thank you very much for saying that we can hear you from YouTube live. Thank you, and I really appreciate that. Good afternoon, ladies and gentlemen. I am trying to let you know the situation of things with regards to the technicalities that we may face in future with regards to using the Zoom court hearing. I want my clients and my fans to be aware of this, and you put yourself at alert. I am a lawyer, and that is the reason why I'm telling you. And I am not here to criticize the system, but I'm saying categorically that the system won't work. The system will not work in a way that it is difficult to hear each other. If there is an accent, it doesn't matter whether it's English, there's going to be a problem to hear each other. When the other party is using a Newcastle accent or Liverpool accent or Scottish accent or X-Way accent or Asian accent or African accent, unless a proper English is used, there's going to be a problem. What do I mean by proper English? Is to speak slowly for each other, slowly, and calculate time for the other person to pick it up. Today, this morning, in the court hearing that we had in the at a Hatton Cross online hearing, we're not allowed to record it, but I'm giving my feedback and my experience back to the public at large. The court hearing was based on the fact that the Home Office refused my clients. We did CRM. So basically, we did not talk about the full here. We didn't come to conclusion on the case today. What we did today is to iron the complexities and technicalities in the rules on the issues as to the reason why the Home Office refused my client on family life. Now, they will refuse my client on family life because he came to UK a very long time ago as a student, and he overstayed his status. He overstayed his status, and he did not notify the Home Office his presence in the United Kingdom for a very long time. He now later on decided to make an application to the Home Office. So many times he has made so many dirty applications. But the last one was when he came to my desk and I look at his case. He has a British partner, but there are no children, no child between two of them. But when I look at his case, I calculate the time he has spent in the United Kingdom. He has spent 19 years from 2001 in the UK. He married to a British citizen some 2 years back or 3 years back, but they haven't got child. He's an overstayer. So, of course, there will be a technical issue there. This morning, the Home Office raised that from 2007, they are not aware of his staying in the UK legally or lawfully any longer. The judge wanted me to confirm to that effect whether I have instructions. I said to the judge that I have no instruction on that, so I will not allow the Home Office to come to conclusion on that matter until I take a further instruction from my clients. We look at the documentation and see the reason for the hearing, and we iron all the documents and things that we will need for full hearing. Now, coming to the final agreement as to the date and what we need to do, the judge wanted them to be in their place for the Zoom hearing or for the video hearing to take place. The Home Office objected and said that the client must come to my office before they will accept the hearing. I objected to that request. I did not allow the Home Office to put it into my mouth. The Home Office don't have the capability to say how it is going to be run. They have been given an opportunity to make a decision on the client case, and the Home Office have failed to come to conclusion on that matter. So the judge asked me, am I willing to accept the client to come to the office for the Zoom hearing? I object to it. The reason why I objected is clearly simple. There are 4 of them in one household. If court cannot take a case on a face-to-face hearing, why should the Home Office push the case to my office for 4 of them to come to my office to come to do face-to-face hearing there? So I disagree with the court and I object to the Home Office request. So in the end, the case is going back to court for full hearing on a face-to-face with the Home Office, with the judge. Everybody will see each other. The reason why the Home Office objected to the client staying in the same house is because they are saying that it will be difficult for them to deal with the witnesses. And I said to them that it basically means that the Home Office is not competent. If the Home Office is competent, you refuse the case on the fact that you did not accept their family life. Now, an evidence is already proving that the client lives with his family, with his wife, the father-in-law, and the mother-in-law. So 4 of them live in the same house. And now, because we are going to have the Zoom hearing, you refuse to accept that 4 of them should be in the same place together. Why the application was also refused in the first instance? Because they did not accept the family life. So the judge asked me, and I submitted, and I said to the judge, I would prefer the case to go back to court so that everybody, including the witnesses and the interpreters, the judge, the Home Office, myself, will be available in court hearing and see each other face to face, rather than running around like Elton Skelter on this matter and wasting my time. It comes to a shock to them the way I handle the matter, but that's the way a good lawyer must handle cases at all times. In the interest of your client, you must not accept any words from the Home Office to put it into your mouth. You must always push it back to them because they have been given an opportunity to make a decision on client matter and they have refused to do so. So they don't have the enormous power. Another issue that we raised today is that we were both given directions. The Home Office and myself was given directions to submit yesterday deadline on skeleton argument. I was given the direction to submit my skeleton argument. I have submitted my skeleton arguments to the Home Office department. 1, 2 page, 3, 4, 5, 6. So I have 6 pages of skeleton arguments submitted on behalf of my client. The Home Office's job is to review my skeleton arguments and return back to the judge whether they are going to go ahead with the case or they are going to withdraw. As we speak on today's CMR, Case Management Review, CMR, the Home Office have not come out with their response to my skeleton argument. So before we finalize today, I actually put it to the judge. Could the Home Office representatives provide the reason why the case cannot be reviewed and submitted according to the directions of the court? Could the Home Office argument provide us the reason why they failed to meet the target of yesterday, which was the 22nd of June? The judge put it back to me in my interest and said to me, Mrs. Olagbaye, don't worry. Let us wait and give them an extension in the interest of your client for them to have the time to review it. Because if the case is properly reviewed, the Home Office is more likely to pull out because I have already squeezed them to the wall. The reason why I said I have squeezed them to the wall is that the client came to UK 19 years ago. The client has a British partner. The client is a family of a refugee from China origin, which means that the father-in-law claimed refuge in UK and it was granted a status. It's no more a Chinese national. It's now a UK citizen because he's got British passport. Also, the wife of the appellant also joined them as a family reunion in 2008 to unite with the family in 2008. So they were all refugee family, even though they are now holding British passport, but they are asylum seekers in the UK. So I have squeezed the case to the end. I have squeezed the case to the end. Now, for us to go ahead, the judge now said to me, which I agreed in the end, that 2 ways. Either the Home Office come back from 14th of July deadline and review the case and come out with us that they are going to pull out or they are going to go ahead. Now, if they pull out of the case, that's the end of that scenario. My client will be given a status. If they refuse to pull out of the case, we are going to have a face-to-face court hearing, not Zoom hearing, on the 3rd of August. I have refused to accept them to do a Zoom hearing in my office. I have told them, if you court cannot take the responsibility to get the case done in the court arena when the environmental situation has calmed down, then we need to wait until things have calmed down. So I refuse to accept them because there are 4 of them in the same household. Coming to my office is dangerous for me at the moment because of the environmental situation. So I cannot accept that. But the Home Office wanted to put it to me, and I said to the Home Office, I object to your request. I am not going to allow the court to accept it. So in conclusion today, ladies and gentlemen, what I want to let you to understand is that the Zoom court hearing is going to be at your client's disadvantage. Believe me, the Zoom court hearing is going to be at a disadvantage for your client. Your client is not going to benefit because the lawyer will struggle and the Home Office will take unnecessary advantage if you are not careful. And if there is any other practitioner out there listening to me, I want you to be aware the situation here on court and Zoom hearing. Do not accept Zoom hearing in case where you have to iron technicalities of law. Always request for a face-to-face hearing in the court arena. The coronavirus situation is becoming more and more less controlled and easy to control now. So by the time we are in the month of August, we will be clear as to the situation of the environmental situation. And if it's not clear, we will adjourn the case again. We will continuously adjourn the case. Now look at it. August 2020 is when the case is adjourned to. My client will have hit the 20 years. My client will have hit the 20 years because it's only a matter of month difference that we are now fighting on. That is one of the technicalities you have to be, you must be able to pick out in law. So in a whole, we have allowed the Home Office to go for the extension to look at the case, to review it and submit their review by the 14th of July. So I did not accept them to do Zoom hearing in my client's case. It's not worth it. My client is going to lose out. I want to see the Home Office bringing the case before me. I want to see the judge sitting to represent us, to speak independently. I want to see my clients make sure that they are not at disadvantage. I have already asked for a Mandarin interpreter. A Mandarin interpreter is a Chinese national who is going to represent them and speak on their behalf and interpret what they are saying. So in the end, I have moved that case. I have turned things around. So I don't come to public to make noise. I come to public to educate people. Ladies and gentlemen, I'm afraid I have to go for the day. But that is the situation that we have just completed in the court arena. So if you are here and you are listening and you still don't know what to do, there are certain things that you have to make sure that you get a good lawyer to assist you when it comes to complexity in the law. Law is not for everybody. If you think you can read it on Google, it's not a matter of Google. Come to my desk and see me how I have pieces the books. Look, different documents have been pieces all around here. Come and see. If you are on YouTube, this is it. You know, different documentation have been pieces all around just on one person's case, and I can't fail. I don't accept no for an answer. I don't take a case that I will not win. I have to be more clearer. Even though his Chinese lawyers have handled the case in the past, but they were messed up. They were all messed up. But I want to prove to you that being a black woman does not mean that I have to be stupid in brain. Being a black woman does not mean people should judge me with the color or with my sex. They have to judge me with my ability to dismantle immigration law, to iron the technicalities in the law, and to deal with critics properly. And that's what I'm out to do. My name has not changed, Leah Tokunbo Lagbaye. For those who are listening to me or looking at me or who will look at this video later on, my office is in London and I'm a legal practitioner. I'm a qualified solicitor and I represent clients on immigration and nationality law. So if you want me to represent your matters on any technicality matters in the court of law, don't even hesitate to contact me on 0208 309 8808 0208 309 8808. In the meantime, before I leave you on the timeline, let me also put it to you that on the case of EA family member that has left his wife, that they are no longer married and did proxy marriage, I was able to turn the case around again and get permanent residence on a case that the Home Office alleged a proxy marriage and alleged a sham marriage. I was able to turn that case around. After 4 or 5 lawyers have handled that matter, I turned it around and I've got permanent residence for that client. It is down to that client to be grateful to the job I have done. But I have done my job as God has led me. A case that they have alleged on sham marriage, on EA spouse, on a retained right of residence in the United Kingdom, I am able to tell you that I have turned it around to get permanent residence on that case. So that is what I am going to tell you. For now, ladies and gentlemen, I've got to go. There is so much to do in my office. But if you need my work, you need me to represent you, the first thing you have to think of is consultation. If you don't do consultation with me, I am not going to represent your matter. I am not going to take on your case. Thank you, everyone. Thank you. And those who are on Facebook, thank you.